and welcome to Legal Basics with Cyril Law Global. And my name is Sian. Today we're going to talk about adjoint ownership. And I will start with an example. And my example starts with a wedding. Ding, here comes the bride, all dressed in white. So on this wedding day, Peter says, I do to John, and they become happily ever after. So just before they become happily ever after, a person comes and gives Peter and John a bottle and says, Peter and John, put this in your living room. It's made of gold. So now, this bottle, does it belong to Peter or does it belong to John? It belongs to Peter and John. Now, can we say which part of the bottle belongs to Peter and which part belongs to John? No, because they both received the bottle together. That is exactly how adjoint ownership works. It means 2 or 3 or more people own property jointly. That means it is jointly owned, jointly possessed, jointly used, and jointly disposed. Now, if for some reason, along this happily ever after, Peter feels like I do not want the bottle anymore and I need to dispose it, and John decides, no, I want to keep the bottle, is it possible for one of them to dispose their share and the other to keep it? No, because their share is not divisible. So this is exactly what happens for jointly owned property. So how do you know that a property is jointly owned? You will look at the title. On the names, it will name different people without indicating their share. That means there will be no fraction, no ratio, and no percentage. It will just read Peter and John. Sometimes parents pass their property down to their children and they want the children to hold that property together as joint owners. So in Peter and John have three children. They're going to pass it to little Peter, little John, and little Toto together. So it will read little Peter, little John, little Toto. We are not going to be able to divide this property between the 3 children because they are going to be holding it jointly. Now, in adjoint ownership, because property cannot be divided, when one of the people that are owned as the owners of the title, when one of them passes on, then this property becomes the property of the one who is alive absolutely. So that means if for some reason, I don't know who to kill in this story, whether it's Peter or John, I do not want it to be a gender issue, but let's say if Peter goes to see the Lord at the age of 89 and John is left alone, then the property is going to devolve to John absolutely. If Peter and John have passed this property to their 3 children jointly, little Peter, little John, and little Toto, and little Toto dies, then the property will be owned absolutely by little Peter and little John. Now, jointly owned property is good for couples. Why? Because when one of the couples dies, it means that the other couple is able, through a shorter process, to use the property and to contract with it. For example, if let's say, we said we're killing Peter, so if let's say Peter has died and John needs to sell this property to take care of school fees or to take care of her health, then it is easier for this property to go through the process of survivorship. So when Peter dies, all Joan needs to do is to go to the lands registry, present her title, present all the documents pertaining to the property, and present the death certificate of Peter. So what will happen is that the registrar is going to register this property in the sole name of Joan. So that process is called survivorship. Survivorship is a much shorter and much easier process than the process of succession, because in succession, matters go to court and sometimes they take very long, and within that time, the people that are left behind are not able to use this property. So you find that families are stuck. yet they have real property. However, for people who are not couples and who are not a family, it is not advisable to have property jointly owned because, first of all, many people do not understand that if they are no longer here, then the property is going to go absolutely to the other people on the title. They're not going to give any share to your family. It is only going to go to the people who are named on the property. The same way, if Peter and John want to leave some of their property to their family, to their dependents, maybe to their children or to their siblings or to their parents, they need to know that if they jointly own property, if they jointly own property, then the property will only go to one of them. It cannot go to their dependents. And that is the most tricky part about joint ownership. You need to be absolutely sure that the other person that you hold title with is the only person that you want to benefit from this property before you're registered as joint owners. I hope that this broadcast has been helpful to you. I can imagine that there will be many questions. Please comment down below, and and please subscribe and share and stay safe. God bless. Bye bye.